problem in the Tesla High School District, therefore explaining why the school district began to crack down on these problems inside of the school district.
But if she had her hair this color for all this time, and I believe the school, maybe the record is unclear, the school doesn't really have any evidence connecting her to drug sales or drug use. Why is it fair to her to all of a sudden have this policy lead to her expulsion when the drug policy's been there for 2.5 years, her hair color has been there for a year and a half, she hasn't really done anything differently?
Yes, Your Honor. The reason that is an acceptable thing is that in Frederick v. Morse, this court stated that any speech which can be reasonably perceived by the school administrators as advocacy of illegal drug use is regulatable.
But you certainly wouldn't equate It's for Jesus with hair in this case, would you?
Yes, Your Honor. This court should equate them on the basis of the fact that the school board had a reasonable basis to believe that, in fact, Ms. Carter's hairstyle was advocating illegal drug use. Paralleling Frederick v. Morse, in Frederick v. Morse, this court held that Frederick's banner was cryptic and likely would not be understood as anything aside from nonsense by many people. Nonetheless, since this court held that the school board, that the principal's interpretation of Frederick's banner as pro-drug advocacy was reasonable, that despite the fact that his banner was otherwise cryptic, it was still constitutional for the school board to regulate his speech. Likewise, in the case at bar, Ms. Carter's speech, Ms. Carter's hairstyle is certainly cryptic at best, but nonetheless, the interpretation of the school principal as seeing her hairstyle as reasonably, as advocacy of illegal drug use is reasonable based on the two criteria.
Counsel, aren't you trying to have it both ways here a little bit? On the one hand, you're arguing that she's not expressing any message because there's no evidence that she shared her intent to have her green hair be a protest with anybody. And on the other hand, you're attributing the school's message to her green hair, that green is associated with drugs, even though there's no evidence of that either. Isn't that a little unfair?
No, Your Honor. For two primary reasons. First, the school, Ms. Carter has to show that there was, in fact, a single particularized message that people would understand. There's not a single particularized message. Even if this court agrees that there were two equally suitable messages as advocacy of illegal drug use or as a protest against federal deficit spending, then there's not a single particularized message. Furthermore, the second prong of Spence v. Washington also applies, since her alleged message had not a great likelihood of being understood. And furthermore, this court has only held that it needs to be reasonable for school administrators to believe that speech is advocacy of illegal drug use in order to regulate it.
Any final word?
Yes, Your Honor. Because of the fact that Ms. Carter's hairstyle was not symbolic speech because it did not convey a particularized message and was not likely to be understood, and because of the fact that Ms. Carter's hairstyle led to a material and substantial disruption, and, Your Honor, my time is left, and I conclude briefly. Thank you, Your Honor.
Yes.
And because it was reasonably perceived as advocacy of drug use, this court should reverse the Court of Appeals decision and grant the school district's motion for summary judgment. Thank you.
Very well. Thank you, counsel. Yes. Yes.
Madam Chief Justice, and may it please the Court, my name is Ella Cohen, and I represent the respondent, Ms. Zoe Carter, in this matter. Today, the respondent respectfully requests that this honorable court affirm the Moot Circuit's decision and remand this case for trial, because there were genuine issues and material fact presented which made the district court's grant of summary judgment improper in this case. Your Honors, this is a case about whether Ms. Carter's First Amendment rights were violated when she was expelled for wearing her hair in a particular manner as a form of symbolic speech. We submit that her rights were violated because her hairstyle was symbolic, political speech protected by the First Amendment of the Constitution, and the school did not present a compelling state interest sufficient to justify prohibiting that expression. First, Your Honor.
Excuse me, Counsel, are there any other cases that talk about the style of one's hair as being constituting symbolic speech?
Yes, Your Honor. In the late 1960s and early 1970s, there were a number of circuit court cases regarding hair length in school settings. However, we submit that the holdings in those cases do not apply because in those cases, the boys who had their hair in a long fashion did not present a particularized message Honors, the legitimacy of Ms. Carter's claimed message is a genuine issue of material fact, one of the many presented in this trial, which made the district court's grant of summary judgment improper. As this court stated in Hump versus Cromartie, summary judgment is appropriate only when there are no genuine issues of material fact. And this court went on to say in Anderson versus Liberty Lobby that it is not the judge's function to weigh the evidence. So if we look at the facts in the light most favorable to Ms. Carter, we see that her intent was legitimate.
How does she meet the second prong of the Spence test about great likelihood that the message would be understood by those who viewed it?
In many ways, Your Honor. First, because Ms. Carter's hairstyle was so unique and different, it is likely that anybody viewing it would understand that she had a message to convey. Then the particular message becomes clear because just as in Spence versus Washington, her message was embedded with, was imbued with elements of communication. Ms. Carter's hairstyle had three symbolic elements to it. The length represented the growing budget deficit, the color represented money, and the coins represented the government's fiscal irresponsibility. In addition, Ms. Carter's context also gave meaning to her message. As this court stated in Spence, the context in which a symbol is used for purposes of expression is important, for the context may give meaning to the symbol. Both the political context of the time and the context of Ms. Carter's activities gave meaning to her symbolic speech.
So your argument is that at the very least we ought to give her a chance to prove all that at a trial?
Absolutely, Your Honor. And in addition, it is the school's burden to prove that the message was not understood, and they have provided no evidence as to this fact. Thus, Your Honors, we submit that Ms. Carter's hair certainly was speech protected by the First Amendment. And as protected speech, the school can only infringe on Ms. Carter's constitutional rights if they presented two extreme circumstances existed. The first being is if they presented a substantial disruption to the learning environment caused by Ms. Carter's hairstyle, and the second is if they provide evidence that Ms. Carter's hairstyle interfered with a legitimate government interest. We submit that petitioners have failed in proving either one.
Should we defer to the school officials to determine when there's substantial and material disruption? They're the ones that have the obligation and responsibility to maintain the learning environment.
Well, in ordinary cases, Your Honor, yes, it is up to the school officials to create rules and regulations. However, when a First Amendment claim comes to light, the school has to follow the standards of Tinker versus Des Moines, which said that unless there is a material and substantial disruption to the requirements of appropriate discipline in the classroom, a prohibition cannot be sustained. Schools are not to be enclaves of totalitarianism, and unless this is proven by the school, they cannot infringe on Ms. Carter's First Amendment rights.
So if I understand, Ms. Cullen, your position would be that what needs to happen here is a remand for a trial.
Yes, Your Honor. We submit that because of the genuine issues of material fact, this court would best be decided by a jury. There are many issues of material fact. The first, as I stated, being the motivation behind Ms. Carter's hairstyle, and the second also being whether there was a substantial disruption to the learning environment. While petitioner claims that there was a substantial disruption, we submit that there was not. The Fifth Circuit Court of Appeals in Burnside versus Breyer stated that conduct which did not appear to hamper the school in carrying out its regularly scheduled activities or bring the classroom to a halt was arbitrary and unreasonable. In Tinker, Your Honors, there was evidence that the black armbands entirely wrecked a math class, and in Burnside, the freedom buttons caused a commotion and disturbed classes. However, the courts in both cases found that that type of distraction did not rise to the level of a substantial disruption. Any distraction possibly caused by Ms. Carter's hairstyle certainly does not rise to the level of the distraction in either Tinker or Burnside, and thus does not rise to the level of a substantial
But
disruption.
if the teacher in charge of the classroom feels that it is interfering with the ability to carry on, in this case, the test that the teacher was about to give, isn't that entitled to some weight? And how do we simply dismiss that as insufficient?
Well, Your Honor, we do dismiss that as insufficient because we submit that there was no reason for the teacher to stop the test because of the student playing with Ms. Carter's hair. Just as the black armbands in Tinker were a silent and passive protest, Ms. Carter's hair was the same. In addition, the student was silently playing with Ms. Carter's hair, and there is no evidence that any student was disturbed by this. If the teacher, Mr. Mansfield, was distracted by the fact that Ms. Carter's hair was being played with, he certainly could have asked the student to stop playing with Ms. Carter's hair and continued on with the classroom
That
activities.
is certainly a good point, and one that troubles me, that this could have simply, it wasn't Miss Carter who was playing with her hair. It was someone who had come along and played with Miss Carter's hair, and somehow she is the one, she now is the focus of a problem, so to speak, simply because she sat there passively with green hair and someone feeling the coins.
Yes, Your Honor, and just as in Tinker, there was no disruption or disorder on behalf of the student, Miss Carter. Miss Carter was not causing the distraction, rather the student playing with her hair was. And the conduct, Miss Carter's hair, was entirely divorced from actually or potentially disruptive conduct. Miss Carter's hairstyle was not inherently disruptive, rather it was the fact that the student was playing with it. And in addition, there is no evidence that the student was playing with Miss Carter's hair because of the way in which it is styled.
The council, the school board suggests that this was happening, not all the time, but that there were a number of incidents prior to the one that led to her expulsion. Isn't that pattern of behavior something that the school can reasonably take into account?
Well, while there is a pattern, Your Honor, Ms. Carter was never given any warning and was never asked to stop. And although 2 teachers did complain to Principal Blake that students played with Ms. Carter's hair, the complaint was never made about the actual style of Ms. Carter's hair. It is certainly not uncommon for high school students to be playing with their own hair or the hair of other students, and there's certainly no evidence that Ms. Carter's hairstyle was the reason that students were playing with it.
So let me pose this question. I'm willing to concede that perhaps this might all be unfair, but I'm not sure that answers my question. If there's a pattern of people playing with her hair, if there's no question that she's in violation of the school policy, even though she's been in violation for quite a while, why does the school have to give her warning? Why does the school have to wait till something else happens? Why can't the school say, okay, the time has finally come that we think it's necessary